Okay, how is the ADA enforced? And we've been talking throughout this class about ADA lawsuits, and I've been referencing some lawsuit-related issues. But the ADA is enforced in two ways. By private suits, and down here it says suit by the Attorney General. That's like the government lawsuits that we were referring to earlier in the Robles case, where the court said that the government has previously accepted WCAG 2.0 as the standard in its settlement agreements. And that was part of the rationale for saying that that is the standard, or should be the standard, in these private lawsuits. But we're really focused here on private lawsuits. So any person being subjected to discrimination on the basis of disability in violation of the Act or of this part, or who has a reasonable grounds for believing that such person is about to be subjected to discrimination, may institute a civil action for preventative relief, including an application for permanent or temporary injunction, restraining order, or other order. So this is what the ADA allows for, injunctive relief. Okay, an injunction to include in order to alter facilities, to make such facilities readily accessible to and usable by individuals with disabilities to the extent required by the Act or this part. Where appropriate, injunctive relief shall also include requiring the provision of an auxiliary aid or service, modification of a policy or provision, or alternative method to extend to the extent required by the Act or this part. So understand that the ADA only allows for injunctive relief and, as we'll see in a moment, attorney's fees. It does not provide damages to the plaintiff. Now, I want to be very clear here about something. There are state laws that are complementary to or implicated by the ADA. So, for example, in California, there's a law called the Unruh Civil Rights Act. In New York, there are New York State and city and state civil rights laws. And these laws give rise to damages for the plaintiff in the event of an ADA violation. But in states and in lawsuits where the only thing alleged is a violation of the ADA, injunctive relief and attorney fees are the only thing available to the plaintiff. Now, what does injunctive relief mean? It means an injunction to force whoever is being sued to comply with the ADA, either by making their facilities usable by individuals with disabilities to the extent readily achievable, or by providing auxiliary aids or services, like, for example, making a website compliant, or by altering their policies and procedures, like, for example, requiring that they institute a policy allowing service animals. So an injunction requiring compliance with the ADA is the relief that the plaintiff in an ADA lawsuit gets. And now in a section 36.504, right here, in a civil action, the court may grant equitable relief such that the court considers to be appropriate, including temporary or injunctive relief, this is just restating what we just read. This is the relief that's available. Equitable relief means an injunction. It just means there's two types of relief that can be granted in a lawsuit, equitable and monetary. Monetary is money, and equitable means changing the relationship of the parties in some way. In this case, an injunction to require auxiliary aids or services, to make the facilities readily accessible to users with disabilities. These are the types of injunctions that the court can provide for in these cases. And of course, here attorney's fees, which is a big one in these in private ADA lawsuits. In any action for administrative proceeding commenced pursuant to the Act or this part, the court or agency in its discretion may allow the prevailing party, other than the United States, a reasonable attorney's fee, including litigation expenses and costs. So, in other words, a private litigant who files a private ADA lawsuit, like the ones we've been talking about, will be entitled to get their legal fees and costs. And that is oftentimes, in my experience, the really financially painful part of being sued for ADA violations. Okay, next slide. So, This is from a case that I pulled from New York, from the Southern District of New York. And this is specifically to address an issue. That I've been asked about repeatedly in these cases. Oftentimes, a defendant in an ADA case really had absolutely no idea that the ADA law was out there, absolutely had no idea what its responsibilities were under the ADA. Again, as I noted at the very beginning of this class, many small and medium-sized businesses do not have legal teams or in-house counsel or sophisticated law firms with ADA practice groups keeping them up to date on all requirements. And so a lot of people are just running their business and then they get blindsided by an ADA lawsuit. And an issue that I'm often asked about is why they weren't told that the ADA exists and that it's something they have to comply with before they were sued. The response to that from the plaintiff's bar when they hear arguments like that is that the ADA has been in place for 30 years and it's your responsibility to know about it. And that's true. It's also true that small businesses are just trying to run their businesses, and medium-sized businesses and aren't aware of every possible law out there that might affect them. That's not true of those taking this class. I mean, anyone taking this class should now be well aware of this law and at least on a basic level of its requirements. But in this case, the court made clear that in fact there is no notice requirement. Nobody has to tell you that you're out of compliance before they sue you. Now, there was a bill in 2017 called the ADA Education and Reform Act. I don't remember the exact name of the bill, and it ended up not being signed into law, but it would have required notice before businesses are sued. And many state laws require notice of an ADA violation or a civil rights violation, I should say, before a lawsuit is filed, but the ADA does not. So here the court writes, defendant's argument, and it's starting here where I've highlighted, defendant's argument, however, is misplaced, as there is no requirement in the ADA that before commencing a lawsuit challenging the accessibility of a public accommodation, the plaintiff must first approach the defendant informally to seek compliance with the statute. Indeed, in cases challenging the accessibility to the disabled of places of public accommodation, the futile gesture referred to in the ADA has generally been, and we're going to discuss futile gesture here in a second, has generally been interpreted to mean that in order to demonstrate an injury sufficient to establish standing, a disabled plaintiff need not make attempt to access a premises that it knows to be inaccessible. Under Title III's futile gesture clause, once a plaintiff has become aware of discriminatory conditions existing at a place of public accommodation and is thereby deterred from visiting or patronizing the accommodation, the plaintiff has suffered an injury. Okay, let's talk here about two very fundamental issues in ADA law and lawsuits: the futile gesture doctrine and the concept of standing. I'm going to start with the futile gesture doctrine because it's easier. Basically, the futile gesture doctrine says that if a plaintiff knows of ADA violations, he or she can sue to cure them even if they weren't actually encountered. This makes good sense if you think about it this way. If an ADA plaintiff or a disabled person actually goes somewhere and there's a step and they can't get in, right? Because there's no ramp. It wouldn't make sense for them to have to sue to get a ramp, and then when they come in, because the ramp has been provided, to find out everything else is inaccessible and file another lawsuit. So if a disabled person filing a lawsuit knows of other violations against this in the same property against the same defendant, those are all brought in the same lawsuit. Oftentimes, again, an issue I run into where a business owner will say, well, how do they know my bathroom isn't compliant or my countertops aren't compliant if the person was not able to get in? And the answer is that the plaintiff's attorney probably did a pre-suit inspection to verify that the barriers are really there. And the plaintiff came to know, therefore, that there are additional barriers on the interior. And the futile gesture doctrine means that they can sue to cure those. The concept of standing, I don't want to get into too deeply. It's very complicated, and it probably could be its own, it is a large part of law school classes. But the bottom line is that in order to have standing to sue, you have to be the right person to file the lawsuit. So the question is, as it relates to the futile gesture doctrine, is the disabled person who is suing for a violation that they never encountered the right person to be filing that lawsuit, since they never encountered the violation? So do they have standing to bring that lawsuit? And the futile gesture doctrine means yes, they do, even if they haven't actually encountered it. I hope that's clear and not too complicated. The bottom line here is no notice is required before filing suit. The disabled person does not have to actually have encountered all the violations sued upon in order to be the person filing suit to cure those violations.